Hare Krishna. Welcome to Tax Guru YouTube channel. This is CRO R. Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to video series What Law Says. And today we are going to discuss one case law in-depth analysis under income tax. So let me allow to share my screen. What law says. And today we are going to discuss a case law Vasuki Global Industrial Limited versus Principal CIT Gujarat High Court. Date of order is recently 15th October 2025 and relevant section is section 148A under Income Tax Act 1961. So let's understand facts of the case. The assessee, Vasuki Global Industrial Limited, is engaged in business of what? Cold trading. The GST authorities issued summons to the assessee and conducted an inquiry under the GST laws alleging purported GST invoice fraud and misuse of input tax credit. What GST authorities issued summons to the assessee and conducted an inquiry under the GST laws alleging purported GST invoice fraud and misuse of input tax credit. During the GST inquiry, the DG GST intelligence recorded statements and information regarding the assessee's transactions. Then the income tax department access this information through the inside portal data shared between the GST portal and income tax departments. Based on this GST originated information on the inside portal that the suggested discrepancies, the income tax officer initiated what proceedings under section 148A subsection 1 of the Income Tax Act, which is the pre-reassessment notice inquiry stage before actually issuing reassessment notice under section 148. The assessee disputed the authenticity and correctness of this information, contending that it was incorrect, incomplete, and wrongly attributed to it. So, aggrieved, the assessee filed a writ petition before the Gujarat High Court seeking removal or correction of the incorrect information from the inside portal, directions that no action be taken on the basis of such faulty data, and quashing of the section 148A notice issued purely on that basis. Very, very important. Please note down. If you want, you can take a screenshot of the slides too. So what are the facts? Let again brief it. The assessee Vasuki Global engaged in the business of coal trading. GST authorities issued summons to the assessee, conducted an inquiry under the GST law. During the GST inquiry, the DG GST intelligence recorded statements and information regarding the assessee's transactions. Then income tax department accessed this information through inside portal. Based on that, this GST originated information, whatever the discrepancy suggested, the income tax officer initiated proceedings under section 148A subsection 1, which is the pre-reassessment notice inquiry stage before actually issuing the reassessment notice under section 148. And therefore the assessee disputed the authenticity and correctness of this information, and what assessee seek the removal or correction of the incorrect information from the inside portal between the GST and income tax department. Direction that no action be taken on the basis of such faulty data, and quashing require also seek the quashing of the 148A notice issued purely on that basis. So let's understand what are the issues before the High Court. The key legal questions before the court were: can the income tax department issue a section 148A subsection 1 show cause notice solely based on raw information from the GST Insight portal without independent verification. Very, very important. Then what is the scope of the AO's duty under section 148A subsection 1 post the 1st September 2024 amendment? Is an unverified third-party departmental data feed a valid foundation for commencing pre-reassessment inquiry? Does Section 148A require application of mind and independent corroboration before a notice is issued? So very, very important four issues were under consideration. That is the one, whether the show cause notice solely based on raw information from the GST Insight is whether correct or not. What is the scope of the AO's duty under Section 148A subsection 1 post amendment for September 2024? Is an unverified third party departmental data feed a valid foundation for commencing pre-reassessment inquiry? And does Section 148A require application of mind and independent corroboration before a notice is issued? Let's understand legal provisions. The Section 148A overview, that is Section 148A of the Income Tax Act, introduced by the Finance Act 2024, provides a statutory pre-reassessment inquiry mechanism. The object of Section 148A subsection 1 is to what? Ensure that before issuing a notice under Section 148, reopening of assessment, the assessing officer, the AO, must give the assessee an opportunity of to show cause why such a notice should not be issued. Very important. So under this section, the AO must base the show cause notice on information which suggests that income chargeable to tax has escaped assessment. Pre-amendment section 148A include distinct clauses, that is inquiry by specified authority and show cause notice provision. Post amendment, that is after 1st September 2024, the separate inquiry clause A was omitted, and now section 148A subsection 1 reads similarly to pre-amendment 148A clause B, focusing on giving an opportunity before issuance of the section 148A 148 notice. Let's see what are the contentions and grounds by the assessee. The assessee's principal submissions were the information on the inside portal was wrong and incorrect. The information on the inside portal was wrong and incorrect. The assessee was not involved in the alleged GST invoice fraud and had no causal link to the matters reported. The AO acted mechanically, tweeting means without any application of mind, tweeting the inside portal data as accurate without any independent inquiry, verification, or corroboration, and thus contravene the very scheme of Section 148A. Section 148A fundamentally requires verification by the AO to form a belief that income has escaped assessment. Simply feeding department to department data without analysis cannot justify initiation of proceedings. What Section 148 fundamentally requires verification by the AO to form a belief that income has escaped assessment. Simply feeding department to department, means from GST department to income tax department data without analysis, cannot justify initiation of proceedings. As a result, the 148A notice itself was illegal and void, as it was dedicated on information that was neither verified nor matched with income tax records and had no prima facie link to the tax escapement under the Income Tax Act. So let's see what are the High Court observations. The Gujarat High Court's key findings and observations were: first, mandatory verification duty. The court understood that receiving information on the inside portal per se cannot be the basis for issuing a show cause notice under Section 148A. The AO must verify the information to satisfy himself that the data indeed suggests that the income has escaped assessment. Simply forwarding GST data without AO's application of mind is contrary to the legislative intent of Section 148A subsection 1. Next, object and scheme of Section 148A. The scheme of the Act anticipates that before reopening, an independent AO inquiry is required, a safeguard against arbitrary or mechanical reassessment actions. After the 1st September 2024, that is a post-amendment, procedural safeguards to check misuse are critical. The AO cannot be a mere forwarding authority for other departments' raw data. Of post amendment, procedural safeguards to check misuse are critical, and the AO cannot be a mere forwarding authority for others' departments' raw data. Then no mechanistic initiation. The High Court concluded that initiation of proceedings driven purely by insight portal inputs without corroboratory verification is a roving and fishing inquiry prohibited in tax jurisprudence. The AO must form a prima facie belief with a reasoned basis before Section 148A is invoked. The AO must form a prima facie belief that with reasoned basis before Section 148A is invoked. So let's see what High Court's judgment and held. The Gujarat High Court held the notice under Section 148A, subsection 1, issued to the SEC was invalid as it was based on unverified information received from the GST authorities. The income tax authorities must conduct an independent verification of portal data before issuing any notices under Section 148A, subsection 1. It cannot be used as conclusive proof of escapement of income. Very important. The writ petition was allowed, and the court directed that no action should be taken against the assessee based on such incorrect information. So broader legal impact is that the judgment is significant in reinforcing that the Section 148A is not a rubber stamp tool for reopening of assessment based on other authorities' data. Assessing officer must apply his mind verification and verify an independent assessment before the initiating the reassessment. It protects the taxpayers from automated or data driven notices lacking independent verification. It aligns with due process principles in tax law and limits fishing or roving inquiries. Very, very important. So now we will see our conclusion. So we conclude this discussion on the decision of the Honorable Gujarat High Court that it is important to pause and reflect on the larger jurisprudential message this judgment conveys. This judgment is not merely about quashing a Section 148A notice, it is reaffirmation of the constitutional discipline that governs the reassessment proceedings under the Income Tax Act. The Honorable High Court has clearly emphasized that the Section 148A is a safeguard, not a shortcut. The provision was introduced to prevent mechanical reopening of assessments, especially in an era where information flows seamlessly between the departments through technological and data sharing platforms. So the court has drawn a very important distinction between the availability of information and formation of belief based on the verified information. The mere presence of data on the inside portal, however serious it may appear, of course it may appear, but doesn't dispense with the assessing officer's statutory obligation to apply his mind, verify facts, and establish a live nexus with escapement of income under the Income Tax Act. For the tax administration, this judgment is a clear reminder that reassessment cannot be algorithm driven. It cannot be borrowed satisfaction from another department, and it certainly cannot be a fishing or roving inquiry. And for taxpayers and professional point of view, the ruling reinforces the importance of what challenging jurisdictional defects in the at the threshold, examining the source verification and relevance of information cited in 148A notices, and asserting that statutory safeguards are not illusory but enforceable rights. From a broader perspective, this decision strengthens what the rule of law in tax administration by ensuring that efficiency doesn't override fairness and technology doesn't replace the judgment. In a sense, the Gujarat High Court has reminded us that while data may trigger inquiry, it is only due process that can justify the reassessment. So that's it for today. Thank you so much for patient hearing. So please note down my contact numbers, email ID. If you have any questions, observations, suggestions, any comment if you want to give, then please email, WhatsApp, or you can also comment below this video. So thank you so much. Stay tuned to the Tax Guru YouTube channel. If you are not yet subscribed, then do subscribe it for latest updates like this and various video series going on the Tax Guru YouTube channel. So stay tuned. Bye bye. Take care. Hare Krishna.